What you're going to get tonight is pretty much a defense perspective. I'm going to try to be neutral as I possibly can, but you're going to hear basically what we're going to talk about are defenses against the reptile, but we're going to use that as a common thread, and that common thread is basically going to talk about how to effectively utilize technology. That is, have a tech strategy from when the incident starts all the way to a verdict or to appeal. And if you think your basic lawsuit, you have the incident, we'll talk about how you utilize technology there, how you go into discovery, how you utilize technology. From a defense perspective, the other people that here are defendants, one of the things that we think that we're transforming our practice is how we report. We want those people that ultimately have the purse strings, the people who decide whether or not to pay Mongo some money or client some money or people like that, actually see ultimately what the jury will say. And we want them to feel that as early as possible. And so we make sure that we send video clips of deps, all the bad things in a particular case, key videos and things like that. So we're transforming how we're reporting. In the old days, you would just send a letter out and you would report on something. Well, things have changed now, especially in catastrophic litigation. How do you report and what you do? Then we're going to talk a little bit about mediation, trial presentation, and then ultimately go over some cases with you and ask you, give you some facts and say, what would the reptile theory be in this case? How would you defend against it? And we're going to give you real cases, not cases that are in theory, etc., but actual real cases. So when you think about it, what we're involved in is the redistribution of wealth. My side of the V, we want to pay as little possible as possible. People on the other side of the V want to take the wealth from the defense and transfer it to the other side. I'm going to talk to you about defense strategies utilizing technology and how you minimize that peril. I'm very fortunate to be able to talk to Tom. Tom is one of those people that a lot of times we get parachuted into cases, and the very first thing I'll say to a carrier, sometimes it's a couple weeks before trial, sometimes it's a month or 2 months before trial, and the first thing I said, I will accept that assignment, but only if I have his office involved in the case. And it's amazing what they can do. They can take basically all the data that you have, digital or otherwise, in your file, and transform that and make it into a persuasive, very persuasive tool that you can utilize during mediations, settlement negotiations, motion practice, and ultimately, push comes to shove, trial. And he totally makes a difference.
Well, can I say something? Jack's office also, Maria sitting over here, makes a big difference, because Maria, we can talk to her at any time and say, Maria, we have this, we need clips, we have these files, what do you think? She'll respond back saying, have JPEGs this, these clips are good, I need that. So it's all according to the office too. So we have a relationship with Jack's office that makes our life a lot easier. After we started working with Jack's office some years ago, there's also what happens, it starts becoming synergistic. Now, we used to talk to Jack's office, it would take, say, hours to do something. Now it's like Jack comes in, order pizza, have a cup of coffee, and what do you think of these ideas? And it starts moving along. It's become a lot different because of all the time we spent.
Yeah, and a lot of times I don't even show up at my office, I'll show up at his office, and everybody in his office knows, and we'll start working on preparing a case. How many people here know about the reptile theory? I've heard that before. The reptile theory from a defense perspective is something that we have been dealing with forever. However, over the past 4 or 5 years, people have coined that term, the reptile theory, but in essence, when we're dealing with all the big players on the other side, plaintiffs' firms like Mongo and Larry and Drew and people like that, Klein's office, we've been basically battling that, I've been battling that for the past 30 years or so, involved in litigation with those plaintiffs' firms. So one of the reasons why we stayed on top of technology, because I had to keep pace with them. I was always running and trying to keep up with what they were doing. And we knew that nowadays, it's very important to have a tax strategy if you're going to persuade millennials, Gen Xers, and even baby boomers like me, and greatest generation like Tom. So that's what we're about. So we basically, in the defense side, have talked about that there's this shift of empathy and sympathy over to the safety rule. That is that the plaintiffs capitalize on the safety rule. Your typical construction case that we have with Mongo, he will always start off, or Larry, that would you agree that safety is the most important thing that on this job site? Is it important to you that people go home and see their children at night? Is it important when they kiss their wife in the morning that they actually show up at 4:30, 5 o'clock and walk in the front door? And of course the defendants are always going to say yes. And would you agree that you're responsible for safety? And if you had a choice between doing something that's safe or unsafe, you would do the safe thing. And so they set up the general principles of the safety rule and then slowly go over, once they get you into a rhythm of agreeing to these general principles, of basically showing you how you violate it. But the safety rule, the way that this works is that what they are trying to do is basically have the jurors actually get a fearful response, that the jurors believe that now they are the guardians of safety for society. And they don't want these safety rules to be breached by defendants like we represent, whether it's a product manufacturer, a construction contractor, etc. And so they're there to protect their families and the community. And often that we go to trial, and jurors have been told by the plaintiffs in the opening, your job is you are the guardians of community safety. And I'll object, and I would say about 60% of the times I'll get instruction to the jurors right off the bat, and the judge will say, no, you are not the guardians of safety. You're to listen to the facts. You decide what facts to believe or not, and then you apply to the law, etc. Sometimes it works, sometimes it doesn't. So we've seen this shift, that there's this revolution that's going on. There's actual courses and seminars and books, and if you take a look at them, this number changes on a daily basis. $6.3 billion and $28 million last week in settlements. They tell you how to take the corporate rep debt, the OSHA compliance officer, things like that. There's this whole game plan how to effectively deal with that. So you're dealing with the safety rule. Why was there this shift to the reptile theory from basically the empathy and sympathy theory? Why do we have that shift that's taking place? And a lot of it has to do with our society that we live in. Think about this election. Think about how polarized and angry different groups are at each other. Think about whether it's socioeconomic, political beliefs, that there is this clash and people don't want to take responsibility. So a way to capitalize on that is the reptile theory. That's not their fault. Also, just the jurors, the makeup of the jurors nowadays, that 75% of the overall panel, not the ultimate jurors that sit in the box, that they will be Gen X and Gen Y, just from a mathematical basis. So when does the plaintiff unleash this reptile theory? I think you might have to. Was not yet? Okay. Here's a perfect example. I represented Sean Benshop, the excavator operator in the Philadelphia building collapse. I was in court with Bob, and I had just won a motion, not against Bob, but on a cross-claim on a case that we had where an ultraman lift came down across 20th and Walnut Street, where one person died, multiple people were seriously injured, property damage. Literally walked out of the courtroom and we got the call that this was taking place. And so we met and we talked, went down, got an order from the judge, about preservation of evidence, and the very next day we were out at the site and we were examining, and our experts were out there. The reptile theory and the reptile, plaintiffs were doing something that was very important. They were priming the potential jury pool. They were priming the politicians who now would react. They were priming the judiciary at that point. They were priming OSHA's reaction, L&I's reaction. So they were building up this momentum of priming at an early stage. So we were basically finding ourselves with an uphill battle early on because the reptile theory is just starting to hatch. We also saw that take place during the Amtrak. Amazingly, the cap was raised for the amount that could be an issue in there. But there were the press conferences right away. If you go back and take a look at those press conferences, you will hear safety, violation of a safety rule, people could have been saved, etc. So there's priming taking place with the reptile theory before a lawsuit ever gets filed.
If I could say something real fast, Jack. Notice Jack was talking about priming. The media was getting primed. Everyone was being primed. But notice at the same time, so go back and look at those press conferences. Could you have done that 10 years ago? No. Now you just hit YouTube. Think about the socialization of social media, how that's also being proliferated at the same time. So when you have something that's being discussed on the news, it's also getting tweeted out, someone's doing Snapchat, something else is going on. So think how that just proliferates over time. So
yeah, and that's the important thing about technology. We went out there and we were going through the evidence that Saturday morning, showed up with everybody and we were out at the site. But at the same time, we had a team, we scoured, we took a look at all the potential video cameras all over the place. We knew that the buses had videos. Eventually, the SEPTA bus video shows the wall actually coming down. We actually, and this is all based on social media searches. We found the contractors, we were the ones that found the contractors across the street who actually took the videos of this thing falling down from the opposite direction and showed the excavator arm and the piece of steel, etc. We developed early on all the photographs that people saw for the 5 days leading up to the collapse. And right off the bat, we got that information, and once again, it was because that's part of our tech strategy, is that to gather information, not just push information out. So it's important that you have a tech strategy if you're going to handle catastrophic claims and things of that nature. So it's important to detect it, and once you detect it, you have to have a strategy of how to eliminate it. And I don't know if you've talked about this, but a power theme is extremely important. So you develop a power theme for your defense. That's what we do. We know the plaintiffs always have a theme of their case. They may have sub-themes. And then we deliver that theme through our tech strategy. So that's two things that work in tandem. And nowadays, the tech strategy is extremely important. And I'm not just talking about trial presentation strategy, that you have to have a tech strategy from the beginning of the case. And that starts at the investigation, how you take the depositions, the sequencing of those depositions. If you want to take someone's deposition to basically get, say, a neutral party's deposition and put that on videotape, so now you have a corporate rep of someone else. Now you could basically pit the corporate rep against the neutral person. And the neutral person typically has no dog in the fight, and you could have them go back and forth on a dueling video during the deposition as to who's right and who's wrong. You could also have to have a strategy if you want to pit one defendant against another defendant. Which defendant do you want to put on videotape first? And instead of reading the transcript to them, you show that video clip. Instead of just a video clip, you show a video clip with a document that may have their responsibility or a piece of evidence. And then you fade that out and you bring the other person in. You can't do that unless you think before discovery starts, what is my tech strategy? If you just launch into discovery and don't have that strategy, then ultimately you're not building the case that you want to build, and you're not going to have what you need to support your power theory. So this is the typical defense firm. Luckily, this is what we believe and we see. Philadelphia is so far advanced. This is what happens to the typical defense lawyer when faced with plaintiffs firms like Mongo's firm and Klein's firms and a lot of other great plaintiffs firms in Philadelphia. We are national counsel for different product manufacturers, and we set the defense strategy across the country. It's amazing how far advanced and the skill level of a Philadelphia attorney is compared to other attorneys around the country. I'm a little biased about that, but I see it firsthand in the courtroom. I see it in depositions all the time. It is really amazing how far we advance and how we utilize technology at every stage of litigation. And Tom could talk about that.
I just want to talk, Jack brought up a great point about when he was strategizing with the technology portions and he's thinking ahead. How is this technology going to work? Why does he want to do what he wants to do? Does he want to take witnesses out of order? How is he going to handle things? Is it going to be videotaped? Is he going to offer a document? Is he going to do this interactively? The whole thing that you have to think about too is that along the way, if you're a plaintiff, you may be using that same file to use part as your settlement package because you may be dropping a clip in. If you're going to mediation, you're thinking, well, if I get this good clip, this good soundbite, I can use this during mediation. I may then move it out and say, at trial, if I get a chance to play this clip because I'm going to use it against the same person who's testifying differently, the jury now sees not only the person testifying and the video, but sees what I was asking and maybe the document or something that they marked up, and now they're saying, no, that wasn't exactly right. Now, in the rules, in the federal rules anyhow, and also the state rules, you get a chance to have an errata. So the person's at his deposition, and if you didn't take it by videotape deposition, and you gave them the chance to read and sign that deposition, and it comes back and say, oh, that was a mistake, no, I didn't mean that. They changed their testimony. Well, how do you think that's going to play, though? You can't eradicate that if you're using a videotape deposition. So the judge going to say, no, you can't play the clip? Well, judge, let them explain it instead. So from the plaintiff or defense side, it really does work well.
And one of the things, Larry Pendeski from your office and I and Ben, we spoke at the bench bar down in Atlantic City, and one of the topics I talked about is setting up from a defense perspective, defense attorneys. One thing that we talked about was how we set up a PowerPoint in our file. And I don't really set that up. Maria Reardon here sets that up from our office, but we have a PowerPoint that's for reporting purposes. We keep a PowerPoint that we believe is the plaintiff's opening statement. And I talked to Larry and was showing Larry some of those things, and he was saying, it's amazing, this is exactly what we would have done. All the bad clips of the different parties and of my clients and key documents and videos and animations and stuff, we had all that in. So our client can never say, well, we didn't know that. We didn't know that that person was going to say that. We didn't know that that person came across like that. So now they actually are seeing what they're going to be doing in the courtroom. So you get to that number, whatever that number may be, based on facts in a timely fashion. And you can settle cases earlier, or you can make the decision that no matter what, we're going to go to trial. Then we also do our own opening PowerPoint and a mediation PowerPoint. So we basically have an opening that's also crafted into a mediation PowerPoint as well. So that's a tool that we use from a tech standpoint. So we finish a deposition, pick out the 5 best clips, drop it into a PowerPoint, it's there. So that once we get to mediation, we are building the file to support our PowerPoint. So basically you need to do that and come up with this tech strategy at all these key stages. And Tom's going to talk to you a little bit about tech, how did it evolve and how do we get where we are?
Well, I'll try somewhat. How technology changed the practice of law, I started out actually 40 years ago, so I'm getting a little old. I started out in common pleas, then I went to the feds, and then after the feds I went to the office. But the federal court filing system now, if you're not using PACER, you're not filing. I mean, you're done. State court, remember we used to have to, or years ago, you had to go and get subpoenas so that they could be filled out. Interactive video depths, we're going to be talking a little bit more about those. Required high-tech trial presentations, no paper. Excuse me, if you go to our federal courthouse here, there's 11 courtrooms now that are fully equipped high-tech. The judge will tell you no paper in his courtroom, but he wants you to give him a full file of paper for his back room, you know, for the law clerk. But the whole thing is that you're moving further and further away from the concept of paper and the concept of tangible items in the courtrooms. So, I mean, years ago, you used to have binders for each, you know, for the other side, if it was the plaintiff or defendant. I'm used to saying for the plaintiff. I do a lot of defense work. And the law library, when we were younger, and Jack, you could probably, I think we were talking about this earlier, Jenkins Law Library in Philadelphia, I think most associates, paralegals, and all sat there all day long, all night long. That's where they were. Now, you can just tap in, right? You have LexisNexis, you can just online. And then communicating with clients, experts, and opponents, and that's what Jack, when he just brought that up. He's developing a PowerPoint, he could put that in the cloud, his client could pull it down. He could talk to his client by a mobile video conference. I mean, even if you were just using very simple FaceTime situation, you can talk to your client live. If you're at a video depth, and I know a lot of lawyers will get their files synchronized. I mean, do most of you guys get video synced? Right. Did you ever use the file called a DVT file that you receive? It's called a DVT. That's the deliverable that you get. I don't know if you know this, but in there, you can make your own clips in the DVT file, and it will create a PowerPoint of the clip, sends the video, does the transcript, the testimony, and you can send it to your client. So what you're buying in that DVT, or when you're getting it synced, it doesn't have to be for trial. It's all that pre-trial information, what you need to do. So the communications with the clients, experts have changed dramatically. We do a lot of work for the automotive companies in the country. And we set up client case managed repositories. Those case managed repositories are used because this has changed too dramatically. You used to have, experts used to be local. You used to go to the experts that were kind of local to where you're at. Now, if you have a large case, you're going after the expert who is really specialized in a certain area. But if we have clients now that are working on a case managed repository, we'll have, say, 10 experts that our clients are looking at using on a particular case, say it's crashworthiness or airbag failure to deploy, any of those things. And we will set up the whole case managed file in a database. We will allow them access. Our client knows who went in, who took what, who's doing what, who's watching what. The videos run online, everything. So think not only how effective that is, they don't have to get it to the client, make sure they receive it. The only thing they have to make sure is that they receive their information to get online. You know, in addition to that, we're creating webs of data that said, here's the expert that's going to go against you. So we have 57 depositions, we have all exhibits, we have every CV, we have every motion that went, we know who he did what, when, and where. All that data is set up. So all that's in a case database. How much would that have cost some years ago? Burning CDs, making copies, sending FedEx, did you get it, did you review it? Clients don't worry about it now. They look on and say, oh, we know who looked at what. They checked out these documents. Check them out of the repository. So it's different. And even when it comes to searching across the broad database, you have to be able to think about that in this day. It's changed. It's changed from paperwork. So, Jack, I think that's then. So the evolution or the revolution changed from software. iPhones and iPads. Now you have a computer in your hand that's stronger than what we used to have when we thought we had good systems way back then. I mean, you can take your iPhone now, play videos, go on YouTube, do searches, right? I mean, you can connect. The internet was the big game changer. I mean, you may not remember, but back in when AOL was something, you got mail. The reason why AOL, I think, was anything is because we were using 56 baud modems that would go beep, 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 beep. You were trying to connect and you hoped somebody in your house didn't pick up the telephone. Look at the speed you have now. Wi-Fi is phenomenal. It's incredible what you're using on Wi-Fi. You didn't have anything, those speeds at that time. If you're going direct in, you can do downloads now using Verizon, what, 150 megs a second? It's scary. So you can play video, you can do anything you like. Internet was changed dramatically. Presentation software. We talk about trial director a lot, or sanction and things like that. Have you ever gone back and looked at PowerPoint again a second time? PowerPoint, if you're running it in Windows 8, has all the tools built in. You can take a PowerPoint presentation, and if you want to draw lines, circles, anything you like, you can use it in PowerPoint. It's built into the software. So sometimes you have to look backwards to look ahead. Because some of these programs come out earlier, it doesn't mean they're not trying to stay up with the industry standards. And I think you have to look at that as an idea these days. Communications we talked about. Even in our office, we no longer have analog phones, right? Everybody's using IP phones. The same way you have wireless phones. Think of how the world's changed so dramatically. And we're moving from that into operating systems that are faster, better. I mean, we're probably down to iOS on the Apple side, and we're looking at Windows on the standard business side, or I would say business side, because Apple's too expensive to run servers. But now everything's shifting. I was saying to Jack, I said, now it's moving to the cloud. So now you can be totally disconnected and connected at the same time. So things are changing. So hardware-wise, though, if you click Jack, it's all about space. You have all the space you want at zero cost these days, almost zero cost. You have speed. We have more speed now than we ever had. And portability. So everybody came in with a portable computer, logged on, Wi-Fi. Jeff has his camera set up and streaming out the video. You couldn't have done that even 5 years ago because the speeds of our connections were not good and they didn't stay. You always lost connectability. So these are the things that we think have changed the practice of law. And once it changed, it's not going back. It's just not going to go back. And you just have to get ahead of the game and get in place.
And that's just like the Philadelphia building collapse case when we did the depositions. We would just walk into the room and there were, basically flat screens all around the room. Then all the attorneys had a screen in front of them. The witness obviously had it interactive. All the documents were already bait stamped and downloaded. There was no paper. You just showed up with your computer. You knew what bait stamps you wanted to cross a witness on, and then you would do it. So, this whole concept of the old days, we would pull in the boxes and boxes and boxes of documents and hand one to everybody. It's so much faster, so much more efficient. Pull out the sections that you want.
And then what are you doing, Jack, at that point? You're also creating a new exhibit. So that Bates number, just say it was Bates 1000, and Jack has the witness circle something, underline something, agree to something. Now you're going to call Bates 1000-1, because now you create a new exhibit in the deposition. That can be used. So you've got to think about that too. Think about how creative you could be, because once they do that, you take a snapshot of it, you're now creating from the same document, creating a new document.
So we'll talk a little bit about investigation. How do we utilize technology? Well, one of the things that we did in the Philadelphia building collapse case is that happens. We knew that we couldn't get everyone that we wanted there. So we made sure that as we were taking a look at the site, that we would show them by Adobe Connect, by our iPads, etc. They were viewing the evidence and directing us where to concentrate. And basically there was collaboration going on from people at home office, people from a laboratory, different experts were talking to different experts what we needed to concentrate on. We were actually taking photos and then they were doing measurements. So it wasn't just showing up and documenting the site. It was having a collaboration, interactive event taking place right there. Within a week, we had a 3D model of the entire site based on different photos, etc. Obviously, my client, I'm not in trial right now because the carrier won a DJ action. And so when they won that DJ action, we were relieved from represent Sean Benchop, who now is in there basically without counsel. So we were relieved from that, but all along we had within 30 days, we had everything we possibly needed at that point, just because we had a tech strategy going in and what we wanted to do, what experts needed to get, what evidence we secured from the site, what evidence that we thought was important, to physically taking away some of the bricks and things like that and weighing them, and showing the different types of bricks that were there on that wall going down the center that ultimately collapsed.
Jack was just talking about collaboration and that they have a collaboration using Adobe Connect or something like that. I was asked to go out to a carrier to talk to them about trial technology, and in addition to that, how does court reporting actually roll itself up into the trial technology. And one of the big things they want to do, one of the carriers wants to do, is saying, Tom, this is phenomenal. Can we now, with one of your reporters, sit there and we can watch from the home office? We just want to watch the deposition take place. We want to watch it live. I said, well, yeah, you can watch it live, or you can wait a couple minutes until it's over, because we don't have a videographer videotaping the deposition as a dep being noticed that way. You're just recording the person by another means. The reporter just has it running, capturing that, either booting it up to a cloud, and or the person's just dialing in and watching the stream at the same time. So then the claim rep is watching that, and then when the attorney gets back, then they know exactly the questions or what happened. So,
yeah, and this is so basically, we also create the shared, Tom talked about these safe rooms, we call them. So everyone has different levels of access to a safe room that we create. And so we know exactly what people can take a look at from the first hour after an incident happened, that we will start collaborating as we go through that. Here's an example of Adobe Connect, which we use a lot of different times.
Another huge benefit of Adobe Connect is the type of engagement you can have. We allow such rich content to be displayed, everything from the animations in PowerPoint through to rich high-definition video. One of the things that people love about our product is that it's incredibly secure. We offer a number of ways that you can ensure that people are authorized to get into meetings. These are really critical for organizations like the DoD. Using Adobe Connect in something they call DCO, or Defense Connect Online, their information and their IP is the most important thing to them. They need it to be secure.
So as counsel, we want to make sure it's secure, and all I am is the I. So now I'm just walking around with something, and all these other people that are a lot smarter than me are taking a look at it and directing us what to do or not to do, or what evidence to secure, etc. So that tech strategy is extremely important at that stage. Discovery is extremely important. From a defense perspective, what I always say, cases are really simple to defend. There is, in essence, basically 4 defenses. Either you're going to admit liability and you're going to battle on damages or causation or something like that. Or what we see is the typical case that we get is the plaintiff is going to prevail, and we want our piece of the pie, that little piece of the pie, compared to the other co-defendants, to be small as possible. It's sort of like that story with the 2 campers and the bear, when the bear starts to attack the 2 campers, and the one camper turns to the other and says, how come you're trying to put your sneakers on? You can't outrun that bear. And the same way that I look at cases, the camper replies, I don't need to outrun that bear over there, I just need to outrun you. So a lot of times when we get a case, it's not just pointing the turrets at the plaintiffs, from the plaintiff's perspective. We're taking a look at the defendants. How do we minimize potential exposure from the defense side? So sometimes that our strategy basically coalesces with the plaintiff's strategy on the sequencing of depositions, how we do it, what we want to achieve with those depositions, etc. So a lot of times that's exactly what we're doing. And
so we want to step back, since we're talking about a lot of technology and depositions. We want to talk about the genesis of how some of this technology started. So does anybody actually have a videotape actually in their household anymore? I mean, I know I still have my old kids' Disney ones that are probably downstairs in the basement somewhere packed away. But we've seen that technology go bye-bye. I mean, it's not really there. But back in the early days, and I don't know if you know this, you used to be able to only take a videotape deposition when you needed to take a doctor's deposition because he was a surgeon, he couldn't really make himself available for trial, and or the person was on death's doorstep. And you were able to take the deposition, you had to make a motion, the judge had to approve it. Now, life's changed. I mean, now you just notice a videotape deposition, and I guess you don't get many objections to the deposition going that route. But the idea of the videotape deposition has changed that much that it was usually held because back in that time, the video equipment was so large. If you turn around and look at Jess, he has a small camera streaming it out using either a GoPro or a short little camera on there with mics. But when you would go to a doctor's office years ago, the video cameras were so bad, they didn't have enough light. So you brought big lights in. It was a major production to take a doctor's deposition, and or if it was a plaintiff who was in a sick bed in a hospital, huge production. The notice of deposition always said record by means of stenographic use and videotape. That's fine. And the full production of light camera action. I just want you to understand that videotaping has still kept this, it's a misnomer now, let's put it that way. Video depositions, I changed the name. It's no longer videotape. Video depositions are held at any convenient location. Now, we're here, we could be doing a video dep. Notice the deposition still says record by means both stenographically and by videotape, or videotaping, they still use those terms. I guess it's like Coca-Cola. Can I have a Coke? You really meant like, well, I don't care if you give me a Pepsi or a Coke, or just give me a cola. I just wanted that branding. So that received almost like a branding in its own right. And so the full production went to camera, action, and technology. Technology meaning that the products became smaller, faster, better, more portable, and you can bring it with you. Years ago, when you had a videotape, you had to make sure that original videotape was good, it didn't go bad. Does anybody really have a VCR player in their house anymore? Even Bluetooth. I mean not Bluetooth, Blu-ray. You don't use them. How many of you are on Netflix? Exactly. You stream right in your house, right? So we'll move on from there and say the 21st century's changed this. Now they're powered depositions, interactive depositions, super depositions, call them anything you want, but now it's all, you have everything laid out and you're ready to go. So now, it's still held at any convenient location. The notice of the death still says recorded by means of both stenographic and videotaping, but now it's camera, action, and interactive technology. Have you ever gone to a deposition that was an interactive deposition and it was noticed saying we're going to use interactive technology?
Or the reverse. I mean, I had a situation, I was trying the case last January, picked the jury, wrongful death case, where, actually I'm going to show you some clips from it. We had to fly down and take the medical examiner in Miami. When we got down there, the deposition, we got there, and it wasn't going to, the notice didn't say interactive. But of course, I went down there and made sure that.
And I said to Jack, Jack, it's going to be interactive. It's got to be interactive. I mean, we're talking on the phone. I said, you got to just take equipment.
Right.
And
so the plaintiff had their equipment, but Tom also sent G down. I don't know if you guys met G.
I don't know if you met. Yeah, I think you guys met G, right?
Yeah, G was down there with me, and we had all our stuff. We had everything digital, etc. And luckily we did, because that was a key deposition that was crucial for the trial.
Wait a second, Jack, just stop right there. But here's how contentious it was. That the attorney, the attorney on the other side either was not allowing G to plug in, or the tech people were saying, oh, your stuff won't work with our stuff. We don't have a switch that will allow you in. Well, our guys have been doing this for a number of years, so we bring our own switches. And he said, well, I can fix that. And then we're able to do it. But had it not been that, what would Jack have done? Turn around and say, okay, now we're going to take a break, we're going to set up our own equipment? The point is, it doesn't need to be that way contentious. It just needs to get the facts on the table. Once they realized Jack had what he needed, they should have let him go.
Right, and I mean, that's just an example of, you want to make sure that if you want it to be interactive, that number one, I think it's fair to let everybody know it's going to be interactive. I think you should disclose that fact in your deposition notice. So that's one of the things that I think you should take a look at.
Or you should ask.
Right.
When you receive a notice of deposition, ask. You know, we had one client who was out in representing General Motors, and there was a deposition taking place, and he asked in like writing or something, and he calls the top. We have a deposition ready, and we're doing a doctor, and we're getting ready for trial, and what's that interactive stuff that you guys do? I said, well, he said, I want you to bring a whole set of, I said, you know, this guy's pretty heavy with GM, he says, just bring everything with you, because if they don't let us plug in, we're just going to say, Doc, we're taking a break and setting up. The thing was, though, it was a decent enough, the law firm on the other side was a good law firm. And they knew from their point of view, like, hey, we're just going to get it on the table. And the presenters were nice enough guys that we just said, hey, let's make sure we work in the switches and everything worked out. But Jack, you're exactly right. This is what I. But you have to ask. You got to ask. Are you going to present electronic exhibits via what? So, question is, why do video depths today?
And Tom always kids me. I mean, here's the difference between Philadelphia and New Jersey. I tried a lot of cases over in New Jersey too. We videotape everything. There's not a deposition that we don't videotape. In fact, when I talk to carriers, etc., I say nowadays it is, my view of the world, it is malpractice not to take a deposition. And I'll tell you a bunch of reasons why that's the case. But in New Jersey, all the time, these guys would show up and everybody's, well, what kind of deposition is this? How come he's videotaping? And it's amazing the difference, and how much more effective that is when you're going to mediation or you're doing a presentation or even a motion. If I want to show a judge a clip of it, I'll do it as part of the motion practice. So it's extremely important to do that videotape deposition, regardless of whether other sides are doing it or not.
Because if you don't do it and you're not ready and you're not prepared, this is what happens in videotape deaths.
The evidence that you've looked at indicates without question that your plant manager, department manager, safety manager, department supervisor, and employee all utterly fail to live up to their safety responsibilities, right?
Yes.
Would you agree with me, sir, that their performance was appalling?
Yes.
I was on your corporate rep to do that. Oh, that's being impressive. So that's just one. And this is in the early days. Now, when I'm saying early days, it's like 2013. We're calling that early days. 3 years of technology flies. But you notice what happened there. They did the video clip, but they dropped in the file after, meaning they were able to show the file. Like in something called Trial Director and a lot of other technologies, you're able to turn around, take the video, and still drop the exhibit in after the fact and then show it in that format. So let me just show you another one.
Agree with me that given the population of individuals that you treat that have brain injury and disease that impair their judgment, that it is even more important for the environment that they are coming to be safe?
Yes.
Did the placement of the bench next to the railing comport with building regulations?
Did not.
And just one last question. This entire incident could have been avoided had you not placed that bench in front of the railing, correct?
Correct.
So
Bill McCormick, Canes.
sorry. So that is an example of video clips, taking clips, using the clips, you know, for whatever they need it for. Then you go a couple of years later. Go ahead, Jack.
Just real quick, I mean, that was just a little snippet, but regulation, safety rule, admitted violation, safety rule. So there becomes the theme, and you know, you capitalize on it. You mention it 3 times during your examination and throughout the trial, et cetera, and all of a sudden you are building a great record of violating the safety rule, endangering not just the plaintiff, but the people objecting.
I'm sorry.
What's the cheapest way to get a video deposition?
The cheapest way. Yeah, I guess you have to talk to your local videographers, and I wouldn't know what the cheapest would be. I mean, you have to see what you're using it for. If you're going to schedule as a video deposition, it's all for what area of the country you're in, and their costs are going to range from one end to the other. I don't really know what all around the country what the rates would be for that. Sorry, Joe. Go ahead, sorry.
I just heard, you kind of mentioned it, that attorneys had their iPads when court order was taking things down and going directly to their iPad.
You could do that. I didn't say that. I was actually talking about the claim representatives. The reporter would have an iPad there and it was streaming the video of the deposition. But you can do that. That's called real time, what you're talking about.
Okay.
So a real-time file, the reporter would have instead of actually connected hardwired to you, court reporter's machine is set up and they have a wireless feed. And then you're just going in using something like LiveNote or one of those, which is going to be a streaming software. Normally, years ago it was expensive. Now it doesn't cost anything. And the reporter's notes are coming up and it's actually in a formatted area.
Can you do that with the video too?
Well, you could actually do it in a number of different ways, but you're going to have a rough draft. The reporter's transcript is not going to be perfect, so it still has to be edited. It's a rough draft file. It's unedited, so you really can't even use it after the fact, unless you were using it for, like say you had an associate with you that was highlighting and or marking files that you go back on later. You know, and we found the only reason for using real time was when we had latent deaf mutes years ago, that they lost their hearing, but they don't know how to sign yet. And we would I would sit and put it on the screen so that when I was writing, they could see the English. And they were then able to answer. They could still speak, but they didn't hear anymore. And then we found also Japanese engineers. If you have Japanese engineers for any product, you want to make sure that you're giving them a real-time feed so that they can read what you're saying, because most of the interpreters, unless they travel with their own interpreter, will not have the lingo down. And that terminology becomes very, very, very important if it's a particular screw or a fastener or something. And I've had Japanese expert engineers stop the interpreter and say, nope, and write it out for them until they got the right word. So that's really a good thing, so that you make sure you're communicating well.
I think that's true also with we represent a lot of South Korean corporations, and we've had that issue to make sure that they understand exactly what's going on.
No doubt.
We've had to deal with that as well, especially if they're not in the country at the time. That other case I was telling you about, where we went to Miami, flew back and got off the plane and walked. Basically, I think I was in. I forget where we took the deposition, but we actually did a deposition of somebody from South Korea that night, and we had those same issues. I have an associate who's from South Korea, and we got into it because she knew that the interpreter was actually saying stuff that wasn't accurate to the witness that was taking place. So it was important for us to have that person there, and a key witness in that case.
And just think about that, and also what Jack was doing, he videotaped it. So that if he had to have it verified, he could take that video and hand it to somebody and say, listen to the interpreter, what she's saying, or he is saying to the witness. So then you have another bite at the apple. Had that been only by stenographic means, you lost that whole, you can't capture what you can't have anymore. It's gone.
And just real quick, it's not real time, but
Sorry about that.
example how fast you can make these video clips. We took a deposition, we picked a jury in November, wrongful death case in front of, I forget the judge. Was it? Yeah, I think it was Judge Collins. But the judge ordered the deposition the day before we picked the jury, did a videotape, Charlie from Tom's office, he had it synced right away. We did the clips, sent it to the carrier, and the decision was we're trying the case no matter what. So, I mean, that's how important it is to get that video clip out, not just the transcript, but the carriers basically saw the person perform and what the person said, and they said, we take it to her. So, it was a good decision.
And then just to give you an idea, when interactive depositions moved up, and I like this clip only because it shows you that screen you see down the bottom, that's trial director. And the nice part about it is the doctor who was up in the corner she's been put into a corner just using we use a live Roland staging piece. It allows you then you ever see if you're looking at a commercial person standing in front of you and then all of a sudden they're standing 30 feet back? Well, that's exactly what the switch does. It's a roll and switch that'll let you change the live video feed. So you can corner anybody you like. So when the doctor's speaking regularly with not having to mark anything up, she's then just big on the screen. But when you wanted to show the jury this, who was not going to see her any other time, and or if you wanted to show it to your client, you use this way of working, and also you're making sure she's not just saying, well, it was up in the shoulder, yeah, it was around that area. You're playing it and you're watch when she's going to take a pen and mark. So that's the whole idea here. Using touchscreen technology. This was a smart board back in those days. Now you have touchscreens, they work just as well.
As you can see, the overall structures of the shoulder are close
Pick up
together
the pen
with no separation between them.
and mark.
This x-ray shows that the tendons and ligaments of the shoulder are intact and doing the job of holding the shoulder joint together.
Now
As you
she's
can
back.
see in this
And
film,
then pull up.
there is a large separation between the clavicle and the scapula. This is evidence that the ligament is completely torn and the collarbone is floating in the shoulder.
So the concept here is if you were playing this doctor to a jury and say you're at a jury, or say it's a bench trial, wouldn't you rather see it, have the jury see that? I'm sorry, go ahead.
No. This is great. Now, I'm assuming you can do this in an actual trial. And then, how does that, so she draws a circle around it, and then you have that marked as an exhibit.
Exactly.
And then, is it like a picture that's taken of it? And then if she draws on it again, it's
You can do
another
this,
exhibit?
You could actually,
This
if it's,
layer.
yeah, you
Okay.
could actually do both. That particular thing, you could have stopped at different sections
Okay.
and basically read where the videotape is and say it's 32A, 32B. Or you have the clip and now you have a digital version of it.
Right, because you don't want
can make an exhibit.
the opposing counsel doing anything to it. So that's when you get marked as an exhibit at that point, and then
Exactly.
nothing else can be
Right.
talked
And
about.
we actually have that in depositions all the time.
Do it all the time.
Yeah, we
Each iteration that's done, everything that's touched on, once she drew that circle in that x-ray,
Right.
and the x-ray was digitized. Once, then you would normally turn around and say, can you please mark that exhibit 30A? Thank you. All right, doctor, continue. And say the doctor then, and when they mark that 30A, they do a snapshot. It actually takes a shot of that still shot, just the way it is. Then the doctor doesn't take a clean screen, but marks more on top of that same x-ray. Then it'd be like, after that next marking, can you please mark that as 30B? So now we have, exhibit 30, then 30A, 30B. Now, you could have turned around and said, doctor, I want you to have a clean x-ray, and we're going to mark that as whatever, and can you please show us where, X, Y, Z was? And that, so you want to mark each iteration, each step of the way, so you can play. Jack, I know that I'm dying, because you have one of the ones that you did, but we're not showing to me. Jack had a young girl who was marking on her, where people were standing in a basement or something, and she just picks up the pen and starts marking it, and Jack is actually saying, this is what's going on for the record, but at the same time, the record was already there. But this was early on, and then, the more Jack said, oh, I don't have to do this anymore, I'm just going to say mark each part as we went.
And it was amazing just to show you that how more sophisticated and comfortable younger people are. This was a college woman. There was a frat party. Somebody fell through it was a question whether it was a frat party. Somebody fell through the vent, severely brain damaged, etc. So she just, without me even telling her what to do, she had the board in front of her, she's changing colors, she's marking it, she's talking it. And I was like, man, this is great. I don't have to say a word.
Yeah, it's
She's
just great
like
stuff.
talking and telling the story with it in front of her and marking, well, this person was here, I'm going to mark that person in red. Oh, this person was over here, it's blue. This is, Susie or somebody like that. It was just amazing. That deposition became so important. We were down with Judge Strawbridge. We had all these clips, and Judge Strawbridge said, your PowerPoint got this case out. And basically laid it out from every single key witness, things like that.
Well, and here's the other thing. Since that exhibit's only digital, you have to make sure that the videographer and or the tech that's working along with it, you would want to make sure they either give you a thumb drive, all those. They have to give it to the court reporter, so the reporter marks it and puts it and indexes it into the deposition itself. So you want that marked there because now it became a new exhibit. So that hopefully, if you're trying to get that introduced later, you can. But real important that that happens.
You mentioned following a clip, like on a motion. How do you do that? Like,
We've actually had our staff, we would basically hand it over to the court, but also when we would go to court, we would make sure that we would mark it. We would give it to our adversary on a flash drive, but when we actually got to court, if we were granted, basically if we were granted oral argument, we would show those clips. A great example of it, we did that for motions in limine in a case that we just had. Again, we picked a jury, I think that was in November too, we had motion practice and we were showing the clips as part of our motion, or motions in limine, which we ultimately prevailed on.
I mean, for argument, I could see that. I mean, maybe I could just ask Don Gary's office, but to make it a matter of record and filing it on video.
Well, we mentioned it, but when we were in court, we actually made it that court exhibit while we were arguing the motion. And we actually handed out the flash drive.
Just to piggyback on that, so you're talking about, you give the example of the deposition with the mark things. When you're over at City Hall and you're on trial and you have these digital, are you putting paper copies marked and moved into the record? Is that what you're doing with this stuff? Or do you just get the digital stuff into the record?
Usually it's just the digital stuff. I mean, sometimes they're paper too.
Yeah.
I mean, it's every case we've had a combination of digital and paper.
If you're going to use the same exhibit that you had iterations done, then mark it. And mark it and have a hard copy. So then you can take it and say to whoever, Joe Smith, that's on the stand, say, Joe, I had Dr. So-and-so mark this. What do you think of that? Did you mark it in the same spot?
Okay.
Yeah, that's where you want to, and then sometimes you may want to have a little trial binder of all iterations that were done from each of those witnesses. So you have an index of, everybody that you did by, kind of using interactive. You have an index that, Dr. Smith, Dr. Jones, whatever, and all the iterations, you just have those printed as color. And if you need to, say, Judge, I'd like to introduce this and just spin it around. And if you have an LL, just put it in the LL. I mean, you can get around a lot of different things.
And here's another great thing, and you guys do a great job of this. Larry has a great video that he shows of this, is that if you want to summarize like a key issue or point as to what everyone said, or like that, an exhibit that where do people say this person was, or where did the collision occur, or simple things like that, you can actually show that in one PowerPoint and then draw it out and bring it up. So you could say, is there agreement as to where the plaintiff was on such and such date? Well, this is what this person said. This is what, but actually use the court exhibits. Now all of a sudden you're building credibility with the jury. It's not just you talking. It's them seeing the actual evidence of what different people said. That's always important.
If you have an exhibit that's purely digital, and then during deliberations, the jury wants to see it, how do you handle that technology?
You could print it out.
You have a
So-
printer there on the spot.
We do. We always have a printer. And the other thing that we do, basically to avoid that, and we're going to talk about it a little bit later, is that if it's that important, we will make sure that we have old-fashioned logs too, for a multitude of reasons. So, we just sit near the courtroom, people may see it, when it's not even there. And if a jury, wants to take a look at it, or if the judge wants to take a look at it, we'll have that there too, the logs.
And the big thing is, will the judge let that go out?
Yeah.
So the
A lot
whole
of
point
times-
is, will the judge let it go out? Now, another way of doing that, take all your clips, right, drop them onto an iPad, and you have it ready for the jury. And if it's going to go into the deliberation room, you already have it marked what that exhibit number is. And you can either, the judge may say, you can let that out, only that clip, and what you do is just delete the other files off, and then they can walk in and just bing, clip, and it's just a dead iPad otherwise, meaning it's only used for trial purposes. And we've had that.
I guess it's similar to, if the jury asks, can we have such and such testimony right back?
Right.
Bring the jurors.
Or they come back
into
in
the
and watch
courtroom,
it.
and then the judge will read it, or, et cetera. But now if it's a clip, you can show the clip, and they can come back in.
Or judges or courtrooms that are, I know there's a lot of smart firms out there where they're actually giving jurors like iPads so that while you're playing the clip, they can be watching it. Are they doing that?
Yeah.
We've actually seen this, some of the newer courtrooms, they're actually giving them iPads as opposed to having the screens built in, and they'll actually have a monitor per se, like an iPad, that they can watch and then also learn. We find it to be a big problem, to tell you the truth, and we'll talk about it later, I think, with where you start losing the juror's focus or you don't know where they're at. You know, so
Right.
that's our biggest concern.
You gotta make sure technology is delivering, you know, the evidence in a concise, persuasive manner. You gotta make sure technology is not distracting the jurors from, you know, your story, your theme.
Or just, might as well get into it now. We had a Volvo case in Philadelphia some years ago, and our opening statement from our guy who represented Volvo, he just wanted a photograph, and he walked around the photograph on his chest. And the idea there was that he wanted to make sure the jurors were following along, and he knew they were watching him and watched what was going on in his opening. He also, we had technology throughout the whole case, but he wanted to make sure they weren't in the Philadelphia high-tech courtroom, which is probably about 10 years old, so you know how high-tech it is. It's really bad. You really want to have one large screen so that at any given time, you can look over at that jury pool and make sure that they're actually watching the evidence being presented. You know, if they have little monitors, they can be looking down, but they're really, you know, have their phones out. You know what I mean? So just think about that in the back of your head all the time. If you have one central spot, that's really going to make them focus, or you can make sure they're getting focused, or you can get them back in. Jack, you have the hand, right?
Oh, yeah.
Yours.
I mean, just to show you how old this is 2008.
And that's a smart word.
Yeah.
See that underneath? That's a smart. That's different. See how the color pens. Go ahead, Jack.
Yeah, and this was plaintiffs doing his doctor, and once again, way back when, we got a copy, back in 2008, we got a copy of this and sent it to the carrier so the carrier could take a look at it. And we thought this was it was great what the plaintiff did here. You take a look, you see the wedding ring, and now the doctor's going to explain exactly what's
If you don't have it, check
of his hand. Can you show the jury what the nature of the injuries were that he sustained and that you eventually treated?
Yes. This is very acute after the injury occurred within the first few days. And this, obviously we're looking at the hand. Here's the wrist, okay? And here we're coming down over the index. This would be the long finger and ring finger with the ring still there. What we're looking at is skin that is missing. These areas where there is this darkish appearance, that's coagulated blood. These whitish bands longitudinally, those are tendons, remnants of some. You can see some of those tendons are chewed up a little bit. And so we're missing skin. We're missing some areas where the tendon's not there, and it's impossible to see bone under here, but in this case, where the center right here, that's where the fracture was. So we're looking at the hand relatively soon after the injury with obvious missing components and acute inflammation from the injury.
I mean, that's so effective. And you know, sometimes it's amazing how many times I go to trial in New Jersey where the doctor's just talking about it. Or maybe they'll kick it up a notch and there's a little model of something. But this is what we've been faced with since 2008, even before that. So we knew we had to up our game to be able to basically deal with what the plaintiffs were doing. So it's very, very important. And this is very important too. Imagine going to this deposition and all you sent your carrier was a written report about this, and they didn't get to see this. And they're going to assess value. What do you think is more powerful, this written report or showing them actually what the juror is going to say?
I just want to continue with this, Jack. And if you ever had an opportunity to use a dual camera setup, I don't know if you've tried that with Interactive. I don't mean to take anything here, Jack, but we have one client that's a plaintiff's attorney and in Philadelphia, and he used to be at a firm called Lipton, Blumberg, Madison and Young. His name's Charlie Young, and I've known Charlie Young for probably 40 years. He used to have a lot of cases against George Lavin, who was one of my clients forever. But Charlie Young told me he had a case at that time, I have a medical malpractice case, and that's all he does is job. And he said, we need to do this interactively. He said, I'm a doctor. We need to show the documents to the doctor. I want him to mark up everything. And the doctor was fairly young, but the doctor couldn't travel. He had heart problems. He was only in his 40s. So our whole group flies out to Cincinnati, the night before. We have everything set up. And Charlie said, I don't want single camera. I want dual camera. He said, I don't want a talking head. He said, I want the doctor on the screen. And when I ask the question, I want to be in the corner. So they can see their focus always stays. They don't just hear this question out of nowhere. They can watch me ask the question, and the doctor answers. And he said, then, when the document comes on the screen, pull the doctor into the corner and take me off. So that's how, I was thinking, wow, how is this? What are you doing this for? And he said, Tom, I got $15 million last time for a case like that when I did it that way. And after we got back, 3 days later, he said, got my 15. So that made a difference. This guy, the other, they were screaming, hollering the whole time. Jack. They all screamed the defense. Oh no, you can't do this, that whole bit. And I'm telling you, I do defense most times, but he said, Tom, I'll get it. I know I'll get it. And 3 days after they came back, they settled for 15. So that's what he wanted to do, because he was thinking the technology ahead of time, thinking his case ahead of time.
And just to go back in 1989, I had a case against Jerry Lippman and Jerry McHugh.
Yeah.
It was one of the worst cases, a big explosion at Scott Paper plant. And multiple people died, but the people who lived were even worse. It was the first time I ever saw somebody do a deposition during discovery, way back when, in the 80s. The plaintiff was really, really bad. It was really, we didn't think there was any threat that the plaintiff was going to die beforehand. It wasn't to preserve the testimony. But he actually got a court order, and they did the deposition. And we talked about it way back then, how effective that was. And, not to know that that's going to basically become the standard of what we're doing nowadays.
Well, it's kind of funny, this actual LL.M was Jerry Lippman, trial school, way back. Jack, you know. Well, we're going to give you an idea with this. So Jack was talking about, why don't you talk about position?
Well, this is...
That's why I think we saw this with Larry.
You did?
Oh, good, okay.
It might not be the same clip, it was just
Well,
the
no,
same guy.
why don't we just give you the background of it? It's not the same clip then, but because we put Larry's together too, I'm sorry.
Yeah.
Go ahead.
But this is why I said that it's important that you basically strategize what you're going to do, the sequencing of the deposition. But if you take a look at it, you see you have the person who's involved, the primary tortfeasor there testifying, and you're pitting this independent witness against them. And the great thing, we love this, and we try to do this as much as we possibly can, is you never want the jury to think that you're the ogre, that you're the bad guy. What better way to do that than to have two other people go at each other and you just stand back? So you don't have to be the bad guy in front of the jury. You're not losing your credibility, you're not losing your likability to the jurors. So when you're doing those depositions and sequencing, that's another thing that you could think about, is how do I set up situations like that I'm not just putting my power thing, but I'm going to be the person in front of the jurors, and I want to make sure that they like me and that I'm credible. So let's not do anything during the course of discovery that's going to make me look really bad that ultimately the jurors will see.
And also, just to set this clip up a little bit, Charlie in my office took and superimposed the video of the eyewitness in the corner, because you'll see the actual driver, you'll see a little side piece of a monitor there. He's actually looking at the monitor over here. We just turned that piece around and dropped it in so people can see the effectiveness of it.
Yeah, and that's a great way to basically take in what's in your digital file and make it a persuasive piece of evidence, or using it in depositions, other depositions, or mediations, etc.
Wait, Jack, before we go, can you imagine using this clip at trial, or if you had the opportunity to? You don't have to have a witness that got called for a plaintiff's case in chief, and then you're on the defense side, or vice versa, and say, do you remember what she said? You know, where you get a daily copy transcript saying, 3 days ago, Miss So-and-so said this. You can play this clip and say, just walk away. You don't have to do anything. It's unbelievable what you can do.
Yeah, the great thing, I think I heard somebody talking about, some judges won't even let you use photograph. I mean, it's amazing. You never know what judges are going to let, whether they're going to let you use video clips, let alone, photographs or other documents. But in these types of situations, I think it's extremely effective. I was trying a case probably about 10 or 12 years ago against Mongo, and he, once again, he was using videotapes way back when, but he opened up his case during his opening statement, and he said, I'm not going to tell you what their witnesses said. I want you to listen to him and as to what he said. And he showed all these clips, real effective. They were like 10-second, little clips, etc. It was so effective in front of the jury. It was just amazing how powerful that was, and he knew that it was so more powerful that he was not saying what they would say. They were saying. So his credibility went up like that because he's showing evidence right away. And it's not what he thinks the evidence is, but what the evidence is.
But Jack, look at the platform too. If Bob could have did the same thing by saying, and let me read from this, the jury would have been snoring. You know what I mean? Think about it, right? But when he played the clip, bang, it changes up, it's the dynamic.
Right.
Go to 27, line 9 to 15.
I don't even think we have to play Jack at this point. Yeah. This is strange. We talked about this before. If you have this was done by video teleconference. The witness did not have any documents or animations in front of him. But our client, when they were getting ready to go to a mediation, asked, can you drop in a file so they could see what they were talking about? So Jack, we just use trial director. You can drop it in. If anybody ever played with trial director, there's an area where you can drop exhibits in, and it just splits the screen. It's nothing. Yeah.
Is to replace the flexible spout with a spout that has a spigot at the end of the container, like an igloo cooler. Second, the shape of the container could be modified to have a broader base, which would prevent tipping.
So the idea and the concept is, if you have a video and you have documents or an animation, doesn't mean you're done if you didn't do it at the deposition. You can drop it in after, it'll split the screen. So just think about some of those things. That was like the first one we showed. Magaluzzi was taking the deposition, and then the insert didn't split the screen, it just came up on its own. But the products have gotten so much better, evolved over time. Now you can split screens, the witness stays on the screen, and now you start to see the file come up.
Here's sort of a twist on that, like the witness being in a different location. Maria and I were in a trial. We had just gotten a court order. Somebody was in Newark Airport, actually leaving the country, and a snowstorm. So we knew that there was going to be a snowstorm. We made sure that it was a court order. We got there as a key witness for us. We were up in the hotel. It was me, Maria, Charlie, and G. And plaintiff's counsel doesn't show up. And so we had the witness, got there, plaintiff's counsel didn't show up. But these guys set it up that every excuse that plaintiff's counsel had of not taking the deposition, they basically came up with, I don't know if
Well, Charlie in my office is a real video geek. Just to give you, Charlie's our video geek at the office. I mean, G is very good with the system, but Charlie's is the video geek.
But
so Charlie
he
has
got
Zoom.
plaintiff's counsel basically zoomed the plaintiff in, and then at the same time he started to object as to the documents and exhibits, and then he gave another feed of the documents and exhibits.
Yeah.
That witness became basically the jurors were that the witness's testimony is the reason we got a defense verdict in the case.
Yeah, and I don't know if you've ever used something like that. Charlie was using a product called Zoom back then. Zoom is a Wi-Fi connected mobile video conferencing setup. You can connect up to 25 people at any one time. But here was the nice part. Charlie knew using something that's built into like a video conferencing software. He used people and content, which meant Charlie was able to show the feed of the witness so that the guy could see it. But when the documents were presented, he was able to show content at the same time. So then all objections to the documents the person didn't see, they were seeing them. But that was just a strange example.
Yeah, that was a strange. But that was crucial. I mean, technology saved the day.
Yeah, and it doesn't always. Most times it'll blow up, right?
So
This is you, Jack, I think.
Okay. Here's another reason why I think it's malpractice not to take the videotape deposition. There's so many other reasons, things that are happening on that videotape that are extremely important. It's the mannerisms. I used to prep a client and before videotape depositions, or if a deposition is not being videotaped, I would basically say, take as long as you want. When this transcript gets read back, if it's not videotaped, they don't know if you answered the question in 2 seconds or 20 minutes. So, but dead air, everybody knows what dead air sounds like on a radio or a TV show. The same thing in a courtroom. If you're in a courtroom and there's a witness up there who's fidgety, who looks nervous, looks bad, is sweating, looks totally uncomfortable, the jurors are going to pick that up. If there's always dead air, the jurors are going to pick that up. Sometimes you could basically blend a bunch of strings of I don't know, I don't know, I don't know. How many times or I don't recall. And you know, I've seen people utilize that. I want to play for you his depositions of the things that he did not know. And he did not know this on the project, and he was in charge of safety. You know, how important does that become? So there's things that are happening in the deposition that it's just not that sworn testimony. Here's another reason why we use it. If there's a traumatic brain injury, if there's any type of thing like that, we make sure that we send the videotape to our neuropsychologists. It's part of what they take a look at. We make sure that if there's a biomechanical person, something like that, that's an issue as to what this person can do, their concentration, their ability to, their motor skills, their range of motion. We will make sure that that videotape goes. So it's not just about the testimony anymore. It's visually what's happening there during that video taking place.
Can I say something, Jack? One of my clients had us do a setup. He was going up to talk to a corporate counsel, well, not corporate counsel, I'm sorry, engineers at corporate counsel's headquarters. And they were talking about how they testify, you know, and he wasn't trying to coach them on testifying, but he's trying to tell them to be human beings, you know, take the engineering hat off. Yeah. And so he made us take a clip from a movie called The Verdict. I don't know if anybody ever saw the movie The Verdict, but you have a doctor and they're doing a, you know, pre-examination, and they're just going to do a work through with the doctor. Hey doc, you know, your deposition's tomorrow, so I'm going to go work you over a little bit. And when he would ask them the question, the doctor would be talking all the medical terminology way over the head. And you have the lawyer turns around and says, look, would you just stop talking about it that way? Don't tell us about vomitus, this, that, the other. He said, just say she threw up. The point was, you're not going to connect to a jury if you want to talk, you know, 16 miles over their head. Talk at a level that they understand. And so when you're prepping your witnesses, be they engineers or corporate reps or any of that stuff, get them down to a level that, you know, people are going to understand it across the board. It's a really important situation. I know, Jack, it's a little off for that, but
No, I think that's extremely important.
I just find that
I totally agree.
crazy.
And this is, you talking this, you just the whole, we just talked about the
Yeah, we really
credibility and the deception. You know, you talk about how that occurs over the course of the deposition. Well, if you blend it together into a presentation, it becomes extremely, extremely effective. And it's not just for one witness. I mean, Larry does a great presentation, and you saw this already, where he has sort of, I forget what that's called, celebrity squares and stuff.
That's great.
There's 6 different people that basically blame each other. So it's a great, you know, it's just a great way to put all that stuff together for your closing argument or at a mediation. Or I always say to, you know, for mediation, this is my one opportunity to basically speak to not typically the plaintiff, but typically my co-defendant's adjuster who's there, and show them how bad their case is. And so every mediation, we have a very persuasive PowerPoint that typically we won't even show the plaintiff, but we will make sure that we show the co-defendant's adjuster or the mediator. And it's because we do clips like that and put it all together. Reporting, we sort of talked about this, but just here's a case that tried for about 3 weeks out in Chester County. Plaintiff we represented a restaurant in Westchester, and there was one other restaurant in Westchester that was involved. Person had drinks at our place, left our place, went home, and decided to leave home and go to Delaware to a strip club. And unfortunately, he went off the road and is horrible condition, but basically he was putting $28 million on the board. Because of the deposition that you're going to see, just one little clip, my client decided with a $1 million policy, even though plaintiff was putting $28 million on the board, to take the case to verdict. And they did. They got a defense verdict. But it was all because of these series of clips that we just showed you. Basically one clip. So plaintiff was basically impaired, driving at a high rate of speed. The police officer said that he was reckless. There's a whole legal issue there. Once the police officer says that he's reckless and is convicted, how that plays and what the jury is told. But basically, our thing is we did the typical Google Earth shot if he was safe at home. And so we knew that that would be powerful for the jurors that he left our establishment and he got home. What duty do we have once he decides to leave home? Plaintiff's theory was that he was still inebriated, he couldn't think right, his blood alcohol levels were through the roof. So he decided to do this.
I knew I shouldn't leave again, but I did.
So that clip alone, that he admitted that he knew the state and condition that he was in, he knew that it was a bad idea, and he affirmatively made that decision, and that's what caused his life-changing accident. The jurors were out, I think, and there was a lot else going on in the case, but the jurors were out less than 10, 15 minutes and came back with a defense verdict after a three-week trial.
We're just chasing.
But this is how we report it. So how do you report that? If it's just a letter that it comes across. At this point, this is probably a good time to take a break. Yeah, is that okay? One last thing about depositions, that why videotape is important. Again, this is a restatement of the obvious, but sometimes you have to restate the obvious. How many times do you go to a deposition, or used to go to a deposition, where there is no videotape and the plaintiff starts to do gestures, or points to the injury, or basically shows the range of motion, or a witness, the case that we were just talking about, that witness that we did in the case where the girl fell through the vent at the fraternity. One of the key witnesses talked about how one of the people at the party was reaching up and pushing up on this vent. So I could just imagine, how would I describe that if that was just a transcript? So, but now I actually have it on camera, her getting out of the chair, reaching up, pushing her hands over her head, and me talking about it and basically saying, can you do that again? Can you do that again? I'm getting my threes in and talk about, highlight different points. And then I get her to talk about how the person on top of the vent was jumping and stomping on that. It was so much more powerful to have that take place on a videotape as opposed to if that was just a transcript. So again, it's not just the testimony, it's all these other things that you now can gather and put together.
So it's the old adage, Jack, a picture's worth 1,000 words. What's a video worth, right?
That's
It's got
exactly,
1,000,000 words at that point, right?
that's exactly true. It's so important. Here's some, like, this is something that's probably 15 or 20 years old, but just, it doesn't always have to be the videotape. It could be reenactments. It could be high-tech animation. It could be actually just having somebody reenact an accident. I'm going to show you a couple examples of that. We talked about mediations and how they're important. I represented a property owner where a motorcycle driver was driving by going 45 miles per hour. We have the evidence. Tom's going to talk to you a little bit later about layering the evidence. So we had photos of the scene. We had the measurements in the police report. So we knew exactly where impact was. We knew exactly where he applied his brakes. We knew the line of travel that he was taking. The problem is we're dealing with a still shot. So how do we make that come to life to be persuasive to the jurors and, more importantly, be persuasive? So we agreed to a mediation, and we were there with the mother and the father of this person who was extremely brain damaged. Hit this truck, had a $15,000 policy, so they were coming after the property owner about wrong signage, and there shouldn't have been a left-hand turn into the property, that there were prior violations, that they were supposed to have signage from the township, Upper Darby or someplace like that. So we had to make that come to life. So what we decided to do was basically take all that together and do a test. What does this motorcycle look like traveling at 40 miles per hour? Apply the brakes exactly where the brakes were applied and show where the point of impact versus what would happen if he was traveling the speed limit. So here's an example of the going 40 miles per hour. And again, the rule of three, we wanted to show from different angles and different perspectives. We wanted the juror to see what it was like to be the driver of a motorcycle. And how fast that was. Point of impact went flying through the point of impact, so there's no way that he could have stopped. That wasn't entirely clear, so we wanted to go that way, so he goes past the point of impact. So clearly, our argument was he was at fault, he caused the accident, he was speeding, our claim had nothing to do with this accident. Here's it at 25 miles per hour. The point of impact is that little curved arrow. He applies his brakes, impact never occurs from that side. What would it have looked like if you were the driver of the motorcycle before he was injured? Look how different that is compared to when he's traveling before. Applies the brakes, impact never happens.
You got the exact same kind of motorcycle and that's
Exact same, everything. We have a motorcycle expert who actually teaches Pennsylvania is the accident and construction. It has a whole collection of different motorcycles. So we got exact everything. We wanted to make sure everything was evidentiary, of course. So that's an example. Also, a lot of times in every trial, and when you're thinking about the technology that you want to utilize, you have to decide, you have to pick the battle. Don't let the plaintiff define the issue that's going to be tried in front of the jury. You may not want to try that issue. And don't feel like you have to combat or address that issue all the time. You decide what the issue is going to be. Try to make it a heads-I-win, tails-you-lose situation. You want to make sure that we talk about if you can instigate a fight between other peoples, whether it's the plaintiff and another co-defendant or a co-defendant and a co-defendant, try to set that up. But here's an example of us setting that up at trial.
Where was that white van when you first saw it?
The white van is when that I hit, and I was going straight because I thought that's where the flag was taking me. And all of a sudden the white van is there.
Say the flag was taken.
From what I saw, in the middle of the road.
Sorry, Jack.
And no flag was waved. There was one in the corner. No yellow stuff on. And the flag was grayish color.
Okay, was there a man with the gray flag?
So basically, this is a person who's driving and doesn't see the construction work ahead signs. And there's like 3 of those. I'll show you that in a second. That was actually documented. She doesn't see the 2 big utility trucks with the man lifts up in the air. She doesn't see this. Supposedly, she didn't see the flag man. Well, the flag man was dressed in uniform and sat there the entire trial for us in that uniform and had the flags that he was in. We tried it in Philadelphia, I guess, about a year ago. So we wanted to pit her, the co-defendant, against the plaintiff because, once again, my company was a construction company that was changing the light at the time and had traffic control responsibilities. She was at fault. Again, she only has a $15,000 policy. So, of course, the plaintiff is not mentioning her at being at fault at all. So we wanted to shift and have the jury take a look at her as the cause of the accident. Once again, it was a serious accident that caused him basically to lose this guy's business. So this is what it would have looked like 300 feet. The jurors seen exactly what they saw. They would have seen him there, where she says the guy had a gray flag and he doesn't know that if he was actually out there. So basically that was her view. This is how plaintiff tried to say that he didn't really see this flag person as well. So basically you have 2 people that the jurors couldn't stand, affected their credibility, and obviously they work out for our client.
And do you remember the flagger using his left hand, or you were just using your left hand?
Oh, I mean, I think it was his right hand then. Yeah, he had his right hand. He went like this.
Did he have anything in his left hand?
The only thing I seen, I didn't see what he had in his hand. He had something up in the air, I think, or it wasn't visible. I really didn't, you know, because he was to my right.
So obviously the whole issue was the flag man, and that's why we had the flag guy sat there in his guard the entire time with his flag the entire trial. That I think lasted 3 weeks. And so we basically made it, choose one, true or false. That's basically what we asked the jury. The flag man waved them through the intersection, or the flag man waved Miss Diaz through the intersection. So we made it about those 2, not our particular client. Effectively utilizing technology in the courtroom, you probably heard this already. Make sure that you know your audience. Whoever your audience is, that's who you have to persuade. You need to connect with them. You need to make sure that you're connecting with the core beliefs of the jurors who ultimately are going to decide whether or not they're going to shift that distribution of wealth from your client over to the plaintiff's side. So it's important to understand the jurors. That's a whole other course on how do you pick a jury, how do you investigate each and individual juror, how you monitor the jurors afterwards, etc. But it's important to tailor your message to the jurors. We often, once we find out about the jurors, how we ask the questions, what we ask, how we make objections, it is all to hit their core values that we think are persuasive. And not all of them, but basically those that we think that are going to make a difference back in the deliberation room. So generating this, we talked about this earlier, I went through this, the difference between the jury pool in the United States. See how it has changed dramatically, Gen X and Gen Y from 1995 to 2012. And if we used an updated one, obviously that would be a lot bigger right now. Does anybody know most prevalent ages in the United States right now. You had to pick what age has the most people in the United States. 22. So where do you think, who are the people that you have to convince in the next year, the next 5 years? How are they different? What are their core beliefs compared to other people? And that's who you have to connect with, and that's who you have to persuade. And you need to speak their language in a concise textual way, interactive.
So 22, there's more 22-year-olds than anything else.
Than any other age.
But how does that compare to the jury pool? Because isn't the jury pool really a lot different?
Well, it depends. The jury pool is different, but basically that you are going to get more within the panel, not necessarily the pool that's picked. You know, ultimately, those people sit in a box. But the panel at large is going to be
Younger.
yeah, and you know, I guess not younger, but more made up of the Gen X and Gen Y.
Well, if you look at baby boomers, 1946, that means the earliest baby boomers now like 70, going on 71. They're just going to say, can't go, medical this, don't want any bother, see you later, on vacation, move in.
When do they
Right,
start
just
calling
think
people for
about,
jury duty?
think about this
That's changed.
from a defense perspective. You know, we have a section we do a report. In the old days, Philadelphia was a plaintiff-friendly jurisdiction, et cetera. There's been some, you know, the Fair Share Act and different things have changed that, you know, tincture and things like that. But one of the things that we say now, we don't mind trying a case in Philadelphia. The jurors that we have gotten over the past 3 years or so have been very different than the jurors we used to get about 8 or 10. So when we have to fill out that analysis of the Philadelphia jury, we say plaintiff-oriented, however, things are not as they once were. If you look at the demographics of how many professionals, et cetera, have moved into Center City and what areas of the city have expanded, you also see educational levels have gone up from a defense perspective. Educational levels have gone up, so that potential jury pool, we don't mind it as much. It's dramatically different, the jurors that we get these days versus 5, 8 years ago. I'm just going to flip through this. Only because
Conditioning,
what's that?
conditioning that we were talking
Yeah.
about today.
Right.
Just a little bit. I mean, I just think that, just go back a second, Jeff. We were talking about conditioning only because of this Facebook situation that came out recently with, you know, what's really fact, what's really fiction, what's going on, and, you know, how connected are they. I was doing a presentation with Dave Kloss from Stoltz, and with Dave Kloss and Bill Ritchie. And Kloss just operates in a different world. I mean, he's just way out there. I was telling Jack this today. We had this thing on conditioning, and it was a football game, or you know, what we have is ESPN, and we had 18 seconds of an ESPN situation, and there were 7 different clips going on at the same time. And our big thing was like, you know, pick out the team that came out first. Well, Kloss says to me, oh, I wasn't even thinking about that. He said, I was watching the band around it. I said, what do you mean? He said, yeah, the band. He said, I knew what time my thing was coming on because it would give you the time. And, you know, I knew that, you know, say Penn State's game was coming on, and it was all in the band. He said, I knew I'd go up and go get a beer, make a sandwich, go to the bathroom, come back, and in time for what I wanted to see. I was like, that blew me away. I never even thought about that part. So how I'm conditioned, or how people are conditioned, and how we're seeing things, we really have to think the other way in totality. You know, really broaden our scope, but also the feed. We have to worry about what kind of feed people are taking in.
Right, and that just basically goes to the information overload. One of the defenses against the reptile is, remember I said that priming and conditioning starts at the incident. Well, it also is happening during voir dire. It's amazing the types of questions that you ask. You start to get your themes out in voir dire. Or if there's a horrific injuries, etc., and you already have motions eliminated, you know these horrible photos or whatever it is going to get in front of the jury, you start conditioning the jurors and start to deal with that you're a voir dire. Can they actually analyze that evidence and still be fair and impartial? So you're putting that out there right away. You basically want to take through the course of this tech strategy, you don't want to overload them with too much information. You want to condition them with your gems that support your power thinking. Not too much, but just the right amount that you reinforce over and over and over throughout the trial.
And Jack, we're talking about Facebook, but now Facebook Live, what do you think of that? There's no filter. Oof, it's gone. Yeah, I'm gonna be live. That's scary stuff. I mean, the social, it's just, it's wild. I mean, I'm sure that most of you guys go to trial, you're digging in on the jurors. You have a jury group that's out there picking all the data out. Well, our guys do it all the time, so.
Just, I mean, the case we just got in with your office, is that you talk about about this. There's a product, and once again, the injury and the impact is actually caught on an iPhone. But the crazy thing about it is, at the end of that video clip, there are 3 other people with iPhones. So there's, right there, it's just 4 different sources.
Yeah.
There could be multiple sources in that particular case. That's going to be extremely important to the biomechanical engineer, everybody that's analyzing it from different angles. So this is a case that, our offices just got together, but it's something that's, we've already developed a tech strategy. I'm sure you guys have already developed a tech strategy as well. It's a serious case, but there's so much information that is out there that you got to start to use in a persuasive manner. That's the key. Yeah, and Tom's talking about how times have changed, but basically this is the way we go to depositions in the courthouse. Like now it's like, now people talk about the person with the thinnest briefcase is the one who's going to ultimately win because he has everything together, or she has everything together in a very concise format. The juries expect it, learn more them, utilize technology effectively at trial. Sometimes technology can get in the way. Maria and I and Sarah and Nicole were trying a case up in Newark, I guess, not this past December, but December before that, a really bad wrongful death case. Somebody lights himself on fire in bed. Unfortunately, lives 23 days before he dies. Plaintiff's attorney was utilizing technology, but unfortunately, we talked about the iPad. He would literally walk around and look at his iPad, trying to pull things up, and he was never connecting with the witnesses or the jurors, and it became a major distraction of what he was doing. And I think it really didn't work for him. Even though he was technology savvy, he wasn't utilizing it right. So make sure that you utilize the technology in the right way.
That's right. Yeah, that's a good point, Jack.
You're basically controlling the message, verbal and visual, in the courtroom. You're making it, there's the study out there. I'm going to talk about the study.
I think we may have talked about this before, the Wise-McGrath study showing that if you're presenting things orally only, visually only, or the combination, how over a 3-day period of time the study shows that people retain that information more so.
And here's another example of why I wanted to show you this is you got to kick it up another notch because 65% is not good enough. How do you improve it? Do you do something more than both orally or visually? And I hear and I forget, I see and I remember, but better yet, I participate and I really remember. Make it interactive for the jury. Let them go back and forth. Don't give them all the answers. Don't tell them how to decide. Tell them you want them to decide the case. You want them. You should look at this. So you're now making it an interactive exchange. You're not just sitting there on a podium preaching to the jurors, telling them what to do.
You're teaching.
So you are, it's like the Socratic method. It's a better way. So you're doing something better than both visual and oral. You're making it interactive and multi-sensual. Comments?
Yeah. That's our wake up one, Jack.
Right, go visual and often, Tom's great at that. And here's an example of the CSI effect.
I think they may have seen.
Oh, yes,
Mark
also.
Blount earlier, right?
Okay. But this is a case I had, basically talked about, you get a raw video, how do you make it persuasive to the jurors?
And I think, Jack, just hold on a moment there. Even though we're not playing that, the idea is that video is already in motion, so you need to slow it down. If you have photographs that are not in motion, you need to speed them up. So you have to get both sides of that going on. If you have photograph after photograph, multiple shots, how do you layer those so that they can kind of play and create movement? Because you want the jury to see that movement. If you have a video, it moves too fast, it's too quick, so you need to stop the video at certain portions, highlight certain things that you want to focus on, that you want to focus their attention on, I should say, and then move on from there. So think about taking video, slowing it, taking photographs and moving them at a higher speed.
And this was a case we got parachuted in, and we got Tom involved in it right away, and we basically, no one had done anything, and we just put it all together. And our case was 38 seconds. What could my client do in 38 seconds that the Philadelphia Police Department would do with all their resources? And that was a very, very persuasive message for the jurors. So blended technologies, it's not, you have to hit them on different levels.
Keep it simple.
Yeah, keep it simple. High tech, low tech, no tech. Have your best 3 exhibits. We're talking about technology, but we don't want to overemphasize it. Have your best exhibits on some courtrooms.
Yeah, because if they're sitting around the courtroom.
This was a case that.
Yeah, I forgot to mention this in my opening for Jack. I watched Jack at trial and he kicked it. One of my colleagues asked it, so this is what I'm talking about.
But this was important that we wanted to make sure that we constructed the actual road closure signs, and the jurors had to walk by that every day and every grade to get in and out. So it wasn't just the courtrooms, and obviously this is not technology, but it's something that becomes.
Look at the size. The whole thing is they're massive. I mean, people walk in and it's like, it's tiring. It's a different feel, different effect.
And to the point where I've tried fire cases and we've actually recreated the entire room where supposedly was the cause in the origin that took place, just to give the jurors the proper perspective of where things were and how things could have developed.
Was something like this an exhibit?
I don't think it was ever marked as an exhibit. It was one of the things that was referenced by the witness. I guess it was. I don't remember.
Actually, what happened was that there were exhibits marked in the depositions that were showing the road closure signs, and they were also in the videotape that. So these were just an exemplar of what that sign looked like. So you're bringing an exemplar in, just like if you brought a buck of a car in. It's just an exemplar. So you just leave it there for.
But how do you get the judge's permission to set something up like this in
You just
court?
you approach the judge and ask. Yeah. Literally, just ask.
Don't
Don't be afraid of someone saying no.
You carried them to City Hall at 6 floor.
Well, they actually constructed it inside the courtroom. So for us, that was really important. And the other thing was those lights obviously blink on and off, etc. And make sure that took place during different people were testifying.
Still got a bump over the fly check. It'll fly on its own.
Oh,
That's all right. Don't worry about it. When all else fails, Jack, hit the next one. One more.
Now, these are just different tools that you can utilize as part, obviously, the high-tech courtroom. Now we basically want to talk about language. This is where Tom comes involved. So we get that case about, I guess, a month, maybe not even a month before a trial. And we're asked to try the case, and once again, try the case only if I have Tom Oakes by my side, because I know I have Maria and my other people from my office that will help me out. But
We become Jack's
he's gonna put
extended
this
office.
together.
No, we become Jack's extended office. Maria has the hotline, the G, and we just keep going.
So basically, there's a concept called layering. And why did we talk about that?
And why did it work this time?
Yeah.
Right, we're talking this great. As you can see, talking about the road closure signs, these were the exhibits in the case. So they were marked as exhibits during the deposition. So we're just trying to give you an idea that when you're trying to create, not create an exhibit, but try to show the jury something that's out in the middle of nowhere. But this was out near the airport, it was over the Pratt Bridge, Jack, you know, we used to call it, well, we had different names down there.
Yeah.
South Philly, we both grew up a few blocks away from each other downtown. But we were saying, well, how are you going to show this to a jury and do it well? So you're trying to conceive and put together something that'll work. And Jack usually has all his ideas, and people that work with him have a bunch of ideas what they want done, and they sit down with us and me, Gene, Charlie, and we start putting things together. So we do something called layering. We think layering makes sense in technology. It's all different types of technology, meaning video. It also is the exhibits that you actually have that are now digital, and you can also take Google Earth shots of different areas and start blending them together and create animation at the same time. So that's Jack.
Yeah, and it's one of those things that you're sitting at a conference room table, here's all the photos, here's the police report, here's the sketches. How do you make that persuasive? How do you put that together? How do you make that deliver your theme to the jurors? You could do it, you could just do it exhibit by exhibit. That's not going to be that persuasive or effective, and that's going to take a long time, and you're going to lure the jurors. So basically, what we did was we started to blend raw data, such as...
Right, you have to think about raw data. If you play a videotape, just a video, and, you know, it's the talking head. So sitting there, you have this guy that's going to talk about something very particular, and when he's doing that, you just have that video background, backdrop behind him, and he's going to talk about it. But we're saying, okay, let's take that clip. Let's take one of the pieces that were done in my office where they're just showing movement on highways, take some of the exhibits, and then move from there. Go ahead, Jack.
And so this whole case involved someone on Super Bowl night had too much to drink. There was a road closure of the Pratt Bridge, and supposedly the theory was that the road closure signs were moved because people who worked up on the bridge would go to the staging area to get tools, go back up, it was too cold, etc., move the road closure signs and not put them back. While that was not put back, this person supposedly bypassed the road closure signs, hit two different man lifts on the top of the bridge. The last man lift that they hit, it's so powerful that the turret pin broke and the actual arm was swinging. Two people on land, luckily they were wearing their lanyards, went flying out of the man lift and were swinging around. The person obviously died in the vehicle. My client was the inspector on the project that would be in charge of the road closures and monitor that.
Jack, this is a photograph of, we used to call it Rat Road, Jack, right? And this is a photograph of the scene. Now, Jack, if you click it, you're going to get a Google Earth idea of what that same South Florida we call it Rat Road as kids. So we're taking a Google overhead shot. And that was the same thing as the other photograph, go ahead, Jack. And now here's the video clip. That's raw. Go to the next one.
Was there anyone on the westbound side?
Well, this is what you're going to hear and watch, right? So now, here's the persuasive part. If you can, put the exhibits in, show where they were, put the road sign, and so all we did is take all those little exhibits, put them together, and Jack, you can play it now.
Was there anyone on the westbound side?
Just my vehicle,
Okay, what kind of vehicle was that?
a black Jeep Cherokee.
Okay. And it had lights on top?
I had strobe lights in the headlight, the rear, and I had a flash, I had LED lights in the back and in the front.
The key here is the plaintiff's vehicle is, oops,
That's right.
let me, before I, I'll
Just talk about the
this
time,
is-
it makes no difference.
Right, so the red dot was the plaintiff's vehicle, and we showed that as it was moving, as he was describing it, where it was. One of the issues we always have in construction projects, how do you make something so boring, like designs and specifications, and how do you make that come to life? And one of the things that we wanted to do was to basically show what the road closure was by taking a Google Earth shot. So basically, the jurors could see that every access point, these are the police photos that were taken that night, every access point was closed. And it wasn't our evidence, it was the police photos evidence. So we put that all together to show exactly what had transpired. After we did that, Here's the warrant specifications. This is what we were supposed to do that night during the accident. And we showed that per the plan and the spec, we did exactly what was called. Then we wanted the jurors to come down closer and see the additional signage that had taken place and how there was the road closure with the plan and the spec overdropped. Those GG would basically mean road closure sign.
It's actually shown. So each one of those things were dropped in so you could see what that plan was actually saying. And there's that road closed where he went around.
But imagine just trying to explain that, and now I have something that's visualized and basically taken all those different letters. So that was really important. But the next thing that we wanted to do was, and I think this brings it in, we wanted to let them see what the view was of the plaintiff as he approached, went around the signs, and then eventually up through onto.
I think we killed it at that one, Jack. I think we're going to cut that one out.
Okay. Here's another thing too, is that, you know, how I talk about if you could use other witnesses to get your story, you gain a lot of credibility. Again, this wasn't my client. This was a neutral witness that was out there. That we basically thought that testimony was extremely important, rubber stamping what had transpired that night.
Is part of the reasons you'd want to know about any incidents in which a motorist accessed a closed bridge in early February 2012 so that you could determine whether the joint venture made a mistake, and if so, what could be done to fix it? Is that fair to say?
If somebody accessed the bridge and we found out about it, you want an opinion as to what I think about it, if I'm going to learn from my mistakes? I'm following the traffic control design engineer, and I can't control a motorist or the public if they're breaking the law and they have a driver's license and don't listen to the signs. That I'm not of the opinion that I'm responsible or that I have to learn from my mistakes. They have to follow the rules and regulations.
If motorists were accessing the bridge when it was closed prior to this accident, and you learned that, would that in any way cause you to look at, one, whether you're actually putting the signs up, or two, whether the signs are adequate under the traffic control plan? Would it cause you to look at that?
No, I'm following the design of the traffic control implementing by the engineer that has the expertise to draw it up. I'm not allowed to close the bridge unless I follow it until everybody checks and makes sure they're in the right position. And then I get to close the bridge. Otherwise, I just follow the rules and regulations of the contract document that I'm required to as a contractor to perform my work. The motoring vehicle operator is also responsible, when he gets a driver's license, to follow the rules of the road. If it says closed bridge, stop, they're supposed to stop.
So basically, this was the reptile theory in reverse, is that we were utilizing that there is this dual responsibility of safety. When you get your driver's license, everyone in that jury box had their driver's license. Everyone knows you obey the rules of the road. So we basically wanted to have a neutral witness reverse the reptile theory for us and basically say that there was a violation of the safety rule that night. It just wasn't us. Then we wanted them to see what he would have seen that night as he approached the road closure signs.
Stop sign, Jack. See how Jack was moving, created movement on stills, right? You know what I'm saying, Jack? You're letting them see from a perspective the other way.
And then, yeah, the red dot is the plaintiff, the white dot is our guy who actually sees the plaintiff. Here's one of the clipboards that we basically showed all the road closure signs. People talk about whether or not you could show the jurors. In fact, the jurors actually asked to take a look at this. But it was all the police photos at every point that the roads were closed that particular night. Then we basically wanted to show them how the sequencing of the road closures, how that took place. And when the theory was that supposedly when these two manlifts went up to the top of the bridge, that supposedly that road closure sign was not put in place. But we had the police reports that documented, and the photos that documented that wasn't placed at that point in time. So we wanted to show them come up on the bench. And now we wanted to take the jurors on the ride that plaintiff did that night. Again, these are the police photos, and we wanted them to see exactly what took place. And then as they got closer and closer to the scene, if he was traveling the speed limit that night, he would have stopped right there. But he was also going fast. We know how fast he was going because we had the so-called black box. We knew when he applied his brakes, what his speed was at that point. And that was, we got that data and we recreated the accident. Here's it again, a police report. So it's basic, simple evidence, but we tried to make it animated to show if he was going 45 miles per hour versus 80 miles per hour per the black box, this is what would have happened. See how he hits, and basically he dies at that point, he would have been stopped. And again, this is the police report. We're getting close to, this guy saw this one already. Not sure which one this is.
No, it's the same.
That's the same one.
That's the part.
Okay. Here's the, I didn't want to show you again. I had a big thing one that you already saw. So I'm not going to show that again to you. Here was a case tried last January. I forget the judge. Judge Tucker? I forget the judge in Philadelphia. Again, we got dropped in. There's only 2 defendants in the case. Again, I said to Tom that, it's the
Miami case.
Yes, Miami case. And basically, I represented a product manufacturer who creates peg hooks that are display hooks that you see in every store. And the theory was that there was an altercation that occurred in a hair town, and the owners of the store were chasing these people that were leaving with the product and tried to stop them. As one of the people was around in the corner, he started to slide and slip, and there was video cameras everywhere throughout that store. That particular video camera that shows that area did not show his impact up against the wall. But the theory was that he slid, and the peg hook went in between the 4th rib, pierced his heart, and then you slowly see him die on the camera. The rest of that's all captured. Not only was that plaintiff's theory, that actually was the medical examiner's theory to cause death, matter of death. That actually was the lead detective's theory, who basically said that he was impaled by a peg hook and that he died. So we got the case astronomical demand in the case, and we knew we had to try it. When we first got it, we were just told to control the damages. But we started to take a look at it, and we're looking at the videos, and we're like, wait a second. This guy never went into the peg hook. This guy was actually murdered. And so they basically show you how you take a look at the technology and how you analyze it and how you create a different story and define the issue in a particular case. So this was the single item that the police officer and the medical examiner relied upon, and that was that there was a speck of blood on the peg hook. Nobody ever took the blood sample. We don't know if it was the plaintiff's blood. We see that afterwards he's being treated in that area, so somebody could easily transfer the blood a bunch of different ways onto the peg hook. But because that was there, that was supposedly the product that killed him. The problem with that theory is there's that dent, and if anybody knows fluid dynamics and things like that and blood, that there would have been blood on this peg hook at a bunch of different places if it truly went into between the 4th rib, went through your lungs, into your heart, pierced your heart, and then came out again in the exact same groove. There would have been, just like a dipstick, and that's what we said, just like a dipstick, if you were putting it into your oil, you pull it out, you're going to have oil. The same thing with blood. If you put it in, you're going to have blood. This was where the peg hook was. It didn't match up. All you had to do is do mathematics. And you can see that him on his knees, he would have been far above where the peg hook was that supposedly held him, killed him. Here is the raw video. Is this the raw video? So this is the raw video of the incident.
Side by side. Because you did a mirror image check.
Okay. That's the person who dies who's holding his armpit right there. And now it's reaching up for his shirt. Okay, he ultimately dies like 10 minutes later. He's taken off to that corner there. So the question is, what just happened? You saw that attorneys, 3 different attorneys had this, everybody had this for years. Taking a look at this, took everybody's depositions, etc., and everybody was of the belief that it was the peg hook. So we took a look at it at the time and said, what just happened? Well, this is what plaintiff says just happened. Again, we had, we thought this animation, we were going to use this animation in our opening statement. We thought this was just incredible. It was incredible that there was no fractured. We basically took other things that nobody ever did, and that, like, we took a look at the X-rays and stuff like that. We showed there was no chips. How does this thing just miraculously just go through, never chip or fracture a rib or anything? It go in and come out the exact same route, not have blood, etc. So we had experts talk about that. These were the 3 assailants. Mark Jones had just been released from prison for murder. So, but nobody bothered to take a look at these issues. So again, we made the case about them, not about us. And what we basically capitalize anytime that somebody uses a word, like they always refer, other experts said that a peg hook is the same thing as a spear. Well, to basically capitalize on that and just say, already you're being misled by plaintiff's counsel. But then we wanted to take a look at really what happened here. And this is what happened. So we have the first jab up into the exact place where the plaintiff's animation says took place. There was a nobody ever picked up that he picks up off the floor an instrument which we believe to be the instrument that he was stabbed to. Everybody always said he only had a cell phone in his hand. Well, we just showed that he has a cell phone in his one hand and he reaches down and grabs it. He lunges into the exact area where the plaintiff, he immediately extracts himself from the melee, immediately looks back at him saying, what did you just do? Now you can see blood that's there. And now you see him look at the blood. So it wasn't when he slipped and fell, it's when he has this altercation with that particular person. We see him cupping the instrument in his other hand, his cell phone is in the other hand. Please never pick that up. And we basically have him going down to his knees afterwards. So we wanted to slow down the video. We actually have even more enhanced videos as he comes in from where he allegedly got impaled. We slow motion and stop to show that there's no blood on on his shirt, he comes into the camera, he's not exhibiting any type of injury, etc. But then we wanted to make sure that we, someone talked about it earlier, had still shots and exhibits and blow-ups. So we didn't want to just rely on the video, but we made these basically the key shots that we had. Again, the police officer said that he only had in his hand a cell phone. We basically showed it to the detective. We put on video the day before jury selection, and he admitted that it wasn't an instrument, he was wrong, etc. So we basically got the medical examiner fell apart for the plaintiff, the lead detective fell apart for the plaintiff. And this all happened right before they were being videotaped. And then the surprise witness from South Korea that supposedly witnessed him being impaled totally fell apart as well for the plaintiff. So we just took the key shots. And again, when we got the medical examiner to talk about Tom, got the medical examiner to admit that, would you agree that's the exact entry of the wound where he was pierced. And he admitted to that, and I had him actually demonstrate that. We actually brought a handcuff down, etc. And that went very well for us as well. And so we slowed everything down, just to show them what had transpired. Did you want to say anything about that?
Yeah, someone has a question.
Did anything happen after that? Like once the detective learned?
It's amazing, no, because I guess because I don't do criminal law, but I guess because of double jeopardy. But not only that, they wouldn't even return our calls. We called, we wanted to show them that they were embarrassed at that point. And you know, our position was they literally got away with murder in this case. I mean, it was a convicted murderer who basically picked an instrument up. And it's a very sad case. It really is a shame. But you know, different cases, what we sort of wanted to do was give you some facts and let you kind of tell us what you think the reptile theory would be. What would plaintiff's theme be? Just showing you a couple things. I think this is one of them. But basically, we represented an elevator manufacturer. I don't know if anybody remembers this. It was during when the Phillies actually were good and going to the World Series. There was an accident right after the first, playoff game series. And a person was driving a gator during the day, went through the elevator door at the top on the 700 level. I don't know if it's at 700 level, but whatever the top level is. I'm thinking of that used to be 700 level. Whatever the top level is. Right. Went through the top and actually was traveling so fast, went through the door, and actually went down to the other side, went into the Phillies Fanatics office, bounced off of that, and landed on the car of the elevator that was in the basement of basically the ground floor where they keep all the soda and stuff that they have to bring up to the stadium. His brother was in that, and so the person had died who went down the elevator shaft in the gator. He also went on top of his brother, and his brother didn't know it was his brother at the time, but he suffered brain damage, etc. But he was trapped in there for hours, and literally they had pictures of the brothers below on top of the other brother. So it was a really serious case. Our client was in the elevator. There was a picture of it. What is the reptile theory? What does the plaintiff basically say about that case? Any guess? It's unsafe and extremely dangerous for an elevator not to be there when the door opens. Mr. Green paid with his life for a violation of his common sense safety rule, as his brother is now brain damage. But basically, that the doors and that there were safety regulations, etc., as to the force and strength of the doors, and there were these two little clips. So for the trial, all the plaintiff's big exhibit was two little metal clips that cost like $1.39 each. That had they basically upgraded those two metal clips, those doors would have been there, and this accident would never have occurred. So that was the plaintiff's theme to the case. This is actually a case with with you guys too. Basically, we represented Heaven's Gate. It's a very sad, extremely sad case for everybody. 16-year-old girl there for riding lessons. She's on the horse. Her mother drops her off. She's at the riding lessons. Her mother comes back. An hour later, the daughter was dead. And basically the theme of that case was that when you drop your daughter off for horse lessons, you expect her to be alive when you come to pick her up. And Caitlin wasn't that day. So we knew, again, we got dropped in last second in this case to try it. The other reason that it worked out well, this was an example of utilizing video clips, etc. During a motion practice, but we filed a motion to change venue. Believe it or not, we won in Philadelphia, had an evidentiary hearing on the fact, and got kicked out to Bucks County. Obviously, that changes the whole dimension of the case at that point. But what is the reptile theory? I just basically told you what it was. Our theory of the case was the plaintiff said that the horse was too big for Caitlin, the horse was lame and aggressive, Caitlin was too inexperienced, Caitlin was not properly instructed for emergency dismount. So what we wanted to do is we had all this videotape of Caitlin riding and Caitlin doing these different things. So obviously we're not going to attack Caitlin. What we wanted to make sure that we did was praise Caitlin and talk about how good Caitlin is, and how an excellent rider, and had she been riding since that she was a kid. So it was sort of a switch that we were the ones that were praising Caitlin and the family and the involvement in horseback riding, etc. Whereas plaintiff was forced to basically downplay her experience and her capabilities, etc. And the only reason that we were able to do it is that we had photos of every horse that she ever rode that was bigger, videos of her competing, etc. But it was basically something that we were able to do and only able to do because of technology. I mean, I could not have seen being involved in that case if we didn't have all these videos and try to put it together in a very persuasive manner. There's a bunch of other examples, but I know we're coming close to the end. Sort of wanted to just let you guys ask any questions that you want to ask about. But our viewpoint is try to take a very fresh look at if you dropped into a case of all the evidence. If you're lucky enough to be in a case from the beginning, have a tech strategy of how you're going to deliver your PowerPoint and what you're going to do during the course of discovery. Just don't launch. Launch with a plan and a strategy of what you're actually going to do. And what you'll find is that you'll be able to report cases better to your client. You'll be more prepared at mediation, get cases settled that should be settled. And if you're forced to try a case, you'll be in the best position possible to do so. Well, that's it.
Unless somebody has questions.
Sure.
So I understand when you parachute it at the end of the case, you can kind of dictate the terms because they're in a bad position. But when you have a case from the beginning, how do you deal with pushback from the carriers about expenditures? Because I know obviously your firm is able to spend money, but a lot of firms aren't able to due to carriers saying, we're not going to videotape this, we're not going to spend money on technology.
And we basically,
Yeah, you're right now.
yeah, we basically say that, I mean, here's an example. We have a couple people in our office that do lower end auto work, and we actually get the client to agree to do videotapes, and we'll go in instead of just a simple auto case. We'll have everything like the Google Earth shots and stuff like that we have convinced them that it pays off, and then we show them. We had to get them to agree to do a bunch of different tests in the case, and then we came back and showed how the indemnity dollars dropped. Or the defense costs actually dropped because when we sent the reports and we were saying this person's not credible, it wasn't just us saying it, they could actually take a look at a video clip, etc. It gave them the ability to do things. Another great example is we used Tom's office to do a more cost-effective saving with this one carrier. He actually set up a document, well, he's not set up, but these documents that basically, instead of the carrier calling us and asking us a question, that's a point 2, we go look at our file, that's a point 3, and we communicate back, that's a point 5. They now have direct access.
Right, so what they do is that, say you have a base stamp file, and everybody's on the same page, so that they can dial in, look at the file, and if there's a video, they just play the video and they watch the clip that say Jack or someone at his office has said, look at this time frame to this time frame, and they can then just talk on the phone, and if they're just getting rid of cases, they've had all the material in front of them both at the same exact thing, and they're able to move cases out of this.
So that's just an example. But supposedly other people would get pushback. I just don't think that they're convincing them how important it is to utilize technology.
I used to do the reptile a little bit. I mean, I don't know that much. I mean, I read the book, but to me it's kind of confusing trying to use the reptile and what how Temple teaches in this case with the rule of 3 and the storytelling and kind of put it in there. So to me it was a little.
I would go with Temple's approach.
But I guess you should kind of try to sprinkle it in as a plaintiff's attorney, not sprinkle it in, but try to incorporate the safety rules and the tentacles of danger and all that stuff. You know, it just is to try to incorporate it the way Temple wants you to do it. It just gets a little confusing, at least to me.
Yeah, I would basically say, follow what Temple is basically saying, but one of the things that we're conscious of is, we go through and prep our clients obviously before depositions, depending upon the nature of the case. It may even be a videotape of that deposition. It may even be a courtroom psychologist or someone like that who's now involved in the prep as well. And what we'll do a lot of times is either we know the types of questions from past history that the defense counsel is going to ask, and the types of questions that are going to come forward. When they're going to ask those questions, how to be prepared for those questions. But sometimes we're faced with people that we don't know, and we always make sure that they're prepared to answer those reptile-type questions concerning safety.
So what's your thought, right? So oftentimes I'll put people up and, to your point, I mean, the line of questioning, is safety important? Is safety the most important? If something is, the most safe, you should always do it. I mean, you outlined the beginning. How do you handle your deponents and prepping them for that sort of general, for that approach? I mean, what are you going to say? No, safety's not important.
No, you're not going to say no.
Yeah.
Here's what you could say. And I always tell people this defense when we do closed defense sessions. Instead of the plaintiff, I'll just give you one little tidbit.
Yeah.
One little tidbit is, if you ever take a sandwich down to the beach, one of the things I hate about that when you open it up and there's a little bit of sand in your sandwich, make sure that those questions that you know your client has to admit, make sure they interchange and put in there some of that sand. So basically, don't just give them the nugget, the snippet that they want, but you basically are prepping them in such a way, they're telling the truth, obviously, but they're also getting the truth. Of course, everyone's responsible for safety. We're responsible for safety. Plaintiff in this particular case, they were the competent person for their contract. They were the person that here's their safety policy. So, don't let them define that little question, throw the sand into their sandwich.
And I just wanted to mention something about closings. There was a case that Tom Klein did some years ago. It was a drowning case of a little kid. And when we're talking about technology and cost, Tom Klein probably did something that probably cost him about half hour of his time. And it was a young child who drowned in a public pool. And he just said at the end, he started a little bit of a closing. He said, I'm going to let so-and-so that can see his kid speak. And he played the PowerPoint. And it just said, and it had time running, clock running. How long did it see him on the water? And, Mommy, where are you? Came up with no words, just a little bubble came up with words on it. I mean, no voice, just a bubble came up. 30 seconds later, does anybody know where I'm at? and it ran for 2.5 minutes, and then the child was dead. The point was, they're thinking about their case, as what Jack's saying. Plaintiff side, defense side, just think of it. What you could do to get that across. And I thought that was just,
Yeah.
that was an incredible close.
I actually had an invite-only conference, and Mondo and I actually chaired the conference. It was basically all my carriers and different clients had come together and client lead that.
It's just a great
closing argument. It was just a black screen. It's a black PowerPoint that just come up, and then the words would just pop up and fade back down.
But the clock.
But the clock was extremely important. There was not a dry, these are all seasoned adjusters, etc. There was not a dry eye in the audience when they were talking about it.
But think how long it really took. You just dropped the clock in, little bubble, you know? That's just amazing.
Doesn't that draw a golden rule objection? If your quotes are, "Mommy, where are you?" could the argument be made that you're talking to the jury and having them?
I'm sure, I don't know, with defense, I mean, if I was the defense counsel, obviously I would object even, I would basically say something that, we don't know, how do you know
say
what's
that,
going
right.
through his mind? So I'm sure plaintiffs would argue that, you're allowed to make reasonable inferences, that the way who's down there at the bottom can't get up, and, the evidence is that he can see outside of the water, he just can't get outside.
My
So
background is
it's-
criminal, not civil, and some of these stories are fantastic, but they would have drawn hellfire from the bench if I attempted them.
It's,
That's why there's preponderance of the evidence versus.
It's an interesting thing. One of the other things we talk about with our clients about sort of the shift in some of the judges, that a lot of the criminal judges who came over, I guess about 3 years ago, on the civil side, we found that not that they were trying to be overly defense oriented, but basically because of that mindset, they won't let plaintiff show the things that they want to show during a statement or do things like that. That in order to the benefit of the defendants, you need to, obviously you have to be adaptable. We've walked into court with PowerPoints and the judge says, no, you're not using anything. Well, you've got to be ready to still give your open statement.
Jack, I'm talking about your criminal side. We had a case that we did for a insurance carrier who was plaintiff. It was still a civil case. They had a doctor who was putting up, bills for, it's actually a brain injury, all the coding, and he was billing, I guess, 13, 14 different type of insurance carriers in the state of New Jersey, and every one of them that went after him for, bilking them and all that type of stuff. In fact, he was a chiropractor, so he couldn't even have that coding. But it became so paper-heavy. There was like 500,000 pages that they had. And when they were saying, well, look at this, bill that you had, and you filled this out, and on this sheet, they would have to pass around the jury. And it became like, by the time they got to 3 or 4 of them, the judgment was taking 25, 30 minutes. So the one company that we did the stuff for, Liberty Mutual, said, how can we do this differently? So what we wound up doing is putting everything in the trial director. One side of this page had, here's what the real form is, here's each one as he did it. Click, click, click. So we had 1,000. The point was, technology can help you if you have to think of your different approaches. They were able to get $9 million from the doctor. And the defense were sitting there, the subpoena for all the stuff after that. So there's the criminal side. But the point is, think about your cases, from different juxtapositions that, if it's too heavy in paper, how do I get this? How does this work? What can I do? If you have time, that's the other thing. A lot of you guys don't have time.
Yeah, I'm trying a case, this Thursday and Friday, we're picking a jury. It's with the Plaintiffs' Counsel's Mess's office. As a wrongful death, two people died in a fire. We represent Home Depot, and there was one other defendant, the smoke detector. And 41 motions in limine filed. I would say about 5 of them have to deal with, we didn't file them. So we really don't care which way it goes with the technology or not. We'll do it either way. But other defense counsel filed motions in limine to exclude any of that coming in from, generally speaking, into open statements, as well as individually specific pieces of evidence and video and the fire department arriving, the police videos, et cetera, all that stuff. The bodies being taken out of the house, all that kind of stuff. So that, who knows which way